Hi, this video introduces intergovernmental organizations as actors of international law. In particular, the aim is to shed some light on what we mean by organizations as autonomous actors. We are accustomed to think of organizations such as the UN as an independent international actor. But what do we mean by this independence or autonomy? How is it present in organizations? In order to start sorting this question out, let's start by looking at the definition of an intergovernmental organization. There is, as you may know, no checklist of how to define an intergovernmental organization. This list here summarizes some features mentioned in literature and case law that are expected of an intergovernmental organization. And most of the things mentioned here connect to the idea of autonomy. An organization needs to have a membership for whom it makes decisions. It needs to consist of organs that can make those decisions, and it needs to have a constituent instrument that guides those organs as to what they are supposed to do and how. And the eventual decision made also should not be reducible to a single member state. Now, this is arguably a fairly general conception of the autonomy of an organization. It only gets a little more concrete when we look at the concept of legal personality. Organizations have, of course, for long been recognized as subjects of international law alongside states. And in respect of the members of the organization, the domestic legal personality is often expressly defined. Notably, if we look at the UN Charter, Article 104 in particular, it is a rather open-ended grant of legal capacity. As to international legal capacity, the International Court of Justice famously defined the UN as an organization that has organs, defined tasks, a defined relationship to its members, privileges and immunities, legal capacity, treaty-making capacity, and the court considered that all of this proves that the identity of the UN is separate from its members, and hence the UN is an international legal person in its own right. And this reasoning has ever since been, by analogy, applied to intergovernmental organizations in general. Importantly, the court did also underline that the subject of law in any legal system are not necessarily identical. What the court was basically doing was to distinguish between intergovernmental organizations and states as legal persons. So while states have virtually an unlimited legal personality, organizations are restricted by their aims and purposes, or mandate, as it is sometimes also called. In the following, I will pick up three features of organizations and say a bit more on them: privileges and immunities, membership, and competencies or powers. Privileges and immunities secure a degree of physical autonomy for an organization, you could say. Immunities are one of the classical areas of international law. States, their political leaders, and diplomatic representatives, as we know, enjoy privileges and immunities. The reason for the existence of immunities is that they are considered necessary in order for states to uphold interstate relations. Now, a similar logic applies to the privileges and immunities of organizations. They are thought to be functionally necessary. One of the reasons for this is that organizations don't have a territory, nor do they have a population, as states do. At the same time, there's an expectation that organizations should act efficiently and impartially above all. An organization should not represent the interest of any single state, and the employees of the organization should not identify with the domestic interest of their nation states. Turnaround privileges and immunities also prevent individual member states from exercising pressure towards an organization or its employees. This does, of course, not mean that organizations would have all those immunities that the organization considers necessary. turned around, the fact that organizations have immunities that are functionally necessary also means that it only has those immunities that can be considered necessary. And we see an example of this in Article 105 of the UN Charter. In respect of organizations, there are two main categories of privileges and immunities. There are immunities for the organization itself, and then there are the immunities for the personnel. The privileges and immunities of the organization commonly consist of jurisdictional immunities, immunities against executive measures, premises and archives are inviolable, there's usually a headquarters agreement providing immunities for the headquarters, there are financial immunities, and the communications of the organization is inviolable. In respect of employees of the organization, the extent of immunities vary in accordance with the idea of functional necessity. So higher ranking officials may enjoy full diplomatic protection, whereas lower ranking employees may have very limited privileges. Whereas privileges and immunities constitute a quite concrete expression of the autonomy of organizations, issues concerning membership are more concerned with autonomy as a right to include and exclude states from an organization. The first aspect to take hold of is the right to become a member. In this respect, there is no automatic right of states to become a member in every organization it wishes. So we have a distinction between open or universal organizations and closed organizations. Special interest organizations may be open only for states in a particular region, or for example only for states that produce certain things such as oil. The second aspect has to do with how to become a member. First of all, we have the original members. These are the states who drafted the constituent instrument, and by signing and ratifying that instrument, they became the original members of the organization. But for many organizations, the group that have become members at a later stage can be substantially greater than the original drafters. Now, the right to become a member at a later stage can be subject to requirements. If we look at the UN Charter, Article 4, we find the criteria that are expected in order for a state to become a member in the UN. So in order to become a member, you need to be a state, you need to be peace-loving, you need to accept the obligations contained in the Charter, and be able and willing to carry out these obligations. In the EU, fundamental values such as the rule of law, democracy, and human rights are scrutinized for member candidates. So even if the legal personality of states is virtually unlimited, a state has no automatic right to become a member in any organization it wishes, or certain features may be expected of the state before membership can be considered. Still, another aspect to the question of membership is that some organizations can impose limits upon that membership. In some organizations, there is the possibility of having different degrees of membership. A slightly lower degree than full membership can be on observer status, for instance. This often means that the observer lacks voting rights, for instance, in the organs of the organization. But also the rights that membership brings with it for full members, so to speak, can be restricted by the organization. And one of the examples, which also has recently been used, we can find in the Council of Europe Statute Article 8, which states that if a member of the Council of Europe violates principles of the rule of law and human rights, can be suspended from its rights of representation, or even be expelled from the organization. One final aspect to membership as an expression of the autonomy of an organization has to do with the situation where a state wishes to leave an organization, to terminate its membership. Now, a logical first step is for the state to give a notification on its intentions. But the constituent instrument of an organization may pose conditions on the leaving state. Often there is a time period after which the constituent instrument ceases to apply and the membership is terminated. Another qualification may be that the member should fulfill all its obligations towards the organization. And we of course have examples of this from recent years, like the EU Brexit process, where the 2-year span has been prolonged several times. The point for present purposes is that leaving an organization is not merely a question of stopping to apply a treaty. Finally, the third aspect I will mention is the question of exercise of legal powers. In case an organization exercises binding decision-making powers on its members, this is of course perhaps a paramount example of an autonomous act by an organization. Unfortunately, only a couple of organizations can adopt binding decisions, the EU and the UN Security Council. Still, all organizations perform functions and exercise powers, even if the outcome of that exercise need not be legally binding in a strictly formal sense. What are powers of organizations then? Well, the question is certainly not new for international law, but was addressed already in 1927 by the Permanent Court of International Justice. Two aspects of powers as a source of autonomy can be derived from this quote. First of all, organizations have been provided powers or competences, functions, by its members that it is free to exercise. However, due to its limited nature, it can only exercise these powers. If we look at the UN Charter, these powers can of course be quite extensive. We can consider Security Council binding decisions, and even more so in the EU decision making. But what does it mean that the power has been conferred upon an organization? Does it mean that an organization can only exercise those express powers that can be found in the constituent instrument? Well, no, it doesn't. There is another aspect to powers of organizations as an expression of the autonomy of organizations. And this has to do with the fact that organizations can evolve. So what the organization does in practice is not necessarily found in its constituent instrument. UN peacekeeping is often mentioned as a prime example of a central activity of an organization which is nowhere to be found in the constituent instrument in the UN Charter. But there are numerous examples of non-express powers being exercised by many organizations. So through the exercise of legal powers, organizations make autonomous acts. But they also possess a mechanism for developing and expanding the sphere of action of the organization. This autonomy is at the same time always balanced against the limited personality of the organization. And this dichotomy is illustrated in a nice way, for instance, in the EU treaties, when you compare Articles 5 and 352 and the way in which they emphasize different aspects of the EU. There is a lot more that could be said about all of these aspects of autonomy of organizations. There are also many other questions through which the autonomy of organizations could be looked upon, such as decision-making procedures, the role of experts and secretariats, or the financing of organizations. To conclude this brief introduction, there are multiple ways in which organizations assert an autonomous existence towards its member states. Yet, it is also important to bear in mind, and in order to fully understand organizations as autonomous actors, states can always be found in the background. of the acts of organizations.